2001. On the 6th day of September 2021, the 11 councillors of the third defendant were invited by the first defendant respondent for payment of legislative votes, the legislative votes for the second defendant respondent, and the 6 other councillors who defected from PDP to APC was paid to each of them, while that of the claimant and the 3 other councillors that refused to defect was suspended and withheld. The reason being given by the first defendant for non-payment to the claimant and other 3 councillors was that the first defendant directed her to suspend the legislative vote and every other allowance is approvable to the claimants. To buttress this position, counsel relied on Exhibit A, which is the directives of the first defendant to the first defendant to stop the allowances. It is also stated that the first defendant respondent informed the claimant that the second defendant received and signed for the 90% of the money to be shared after deduction of 10% to be shared by legislative staff. The first defendant respondent also declared that the order directing suspension of claimant's allowances as serving counsellor issued by the third defendant shall remain in force and observed by her until she receive counter directives from the first defendant respondent on the issue. The claimant and Honorable Evelyn Julius Invina on the 6th day of September 2021, on behalf of themselves and other councillors that refused to defect from PDP to APC, met with the first defendant respondent in his office concerning the directives contained in Exhibit A. The first defendant respondent, according to the claimant applicant, admitted issuance of Exhibit A because those affected refused to defect, and until they defect, they will not be paid any entitlements and allowances. And if the claimant refused to defect, the first defendant will activate plan to arbitrarily suspend the claimant and the other councillors that refuse to defect. The claimant, if suspended, together with the other councillors that did not defect as members of the third defendant, they will be denied salaries and any other entitlement and allowances. For the defendants, the claimant is an elected councillor of the third defendant respondent under the PDP following crisis within the PDP in the state. The governor of Cross River State defected to APC, and in solidarity, the claimant and 18 other chairmen of local government areas of Cross River State also defected to APC. Likewise, the second defendant and 6 other councillors defected to APC in June 2021. This development polarized the local government legislative assembly. In line with the rules of third defendant, there was changes in the principal officers of the third defendant. The claimant, who is the minority, became vexed and aggrieved. Vexed and aggrieved, the claimant and the 3 other councillors in opposition to destabilize the businesses of the legislative assembly of the third defendant on 2 occasions, threatened mass mobilization against the person of the first defendant and other members that defected to APC. Apart from the directive, the withdrawal of the subsequent payment of allowances, no any adverse step or machinery have been taken or put in place against the claimant applicant or his collaborators. The payment of legislative votes and constituency project funds allowances complained about is not within the first defendant mandate because it is not backed by any law, and the payment of allowances is subject to availability of funds. The third defendant respondent is currently facing financial crisis. The fund stated in paragraph 12.4 has nothing to do with the payment of any form of allowances, be it constituency project, fund, or legislative boards. The fund received by the second defendant was for additional furnishing of third defendant legislative house. The amount is not meant for payment of councillors' allowance. On the 11th day of November 2021, when this application came up before the court for hearing, Innocent C. Obert Esquire, counsel for the claimant, leading Dixon E. Arifo Esquire and David Echo Esquire, informed the court that the claimant applicant's application is supported by a 27 paragraphs affidavit in support and 2 exhibits and 3 exhibits. A written address was also filed along with the motion on notice. Counsel relied on the deposition contained in the affidavit in support and adopted the written address as his argument. In the written address, counsel formulated a sole issue for determination with whether or not the claimant applicant herein is entitled to the discretion of the Honorable Court sought and prayed for in this present application. In arguing the sole issue, counsel foreseated that the reliefs being sought are within the jurisdiction of the court. Being an equitable remedy, this court can exercise discretion based on peculiar facts and circumstances. Counsel also submitted that the claimant, being an elected counsellor, has the right to enjoy salaries and allowances, fees, perquisites, and benefit accruable. This means during tenure of office, the claimant has a legal right to protect his interests as well as those of his constituency he represents. Counsel submitted it to become expedient to protect this established right of the applicant by grant of an order of injunction. Counsel relied on the case of Okomu Oil Farm versus Tajuddin, reported in 2016, Sri Nigerian Ukulele Report, Part 1499, page 248 at 318 to 319. He also relied on the case of Akafo versus Hakim Habib, reported in 1992, 6 Nigerian Ukulele Report, Part 247, page 260, and also the case of Okafo versus Inaife, reported in 1987, 4 Nigerian Ukulele Report, 64, Part 64, page 129. It is also submitted that the purport of an interlocutory injunction is to protect the existing or recognizable right of a person from unlawful invasion by another. On this submission, counsel relied on the case of Okomu Oil and Tajuddin Sufra, and the case of Abo Sel Dehe Laboratories PLC versus Union Merchant Bank Limited and another, reported in 2013 to MJSC Part 4, page 155. He also relied on the case of Kasumu versus Shitabe, reported in 2006, 17 Nigerian Ukulele Report, Part 1008, page 372 as 394. It is the submission of counsel that at this stage of proceeding, the claimant applicant does not need to prove the merit of his case, but only show that there is an issue to be tried at the substantive stage of the proceedings. On this submission, counsel relied on the case of Kwara Polytechnic versus Afola B, reported in 2010, All Federation Ukulele Report, Part 457, page 629 at 648, paragraph C to D. According to counsel, the affidavit evidence has brought to fore 2 issues of legal and constitutional importance for determination. They are: 1, whether or not Exhibit A, issued by first defendant respondent directing the suspension of the allowances of the claimant applicant who is serving counselor of the third defendant respondent, is valid, lawful, and constitutional. And 2, whether or not it is legal unconstitutional for the defendant to suspend the claimant applicant's legislative counsel because of his position not to yield to the defendant applicant's demand to defect to APC. According to counsel, given the foregoing background, it will be most unfair, most unjust, and most inequitable to allow the defendant respondent to unabatedly continue with their acts of suspending the claimant applicant's allowances and or accomplish their threat to suspend him from the third defendant respondent legislative counsel, even when the issue of the legitimacy of same is an issue yet to be determined in the substantive action before this court. It is submitted that it will serve the interest of justice that the defendant respondents are temporarily restrained from withholding the claimant's applicant allowances as a serving counselor or in any manner stopping, interrupting, or suspending him from the third defendant respondent legislative counsel until every question concerning the lawfulness and the constitutionality of this action of his action in the substantive suit is resolved by this honorable court. Counsel for seated under our jurisprudence, interim or interlocutory injunction is principally ordered and granted for the purpose of preserving the rest pending the determination of the dispute by the court. Counsel relied on the cases of Phuket versus Okpa, reported in 2006, All Federation Cluedo Report, Part 311, page 1895 at 1907, paragraphs F to G. He also cited and relied on the case of Kadia versus Kadia, reported in 2001, Federation Cluedo Report, Part 70, page 1586 at page 1599, paragraph C to D, and also the case of Akako versus Hakim Habib Sufra. Counsel also submitted that in considering application for interlocutory injunction, the threat of the right of the applicant need not to be real or actual because a law, even if perceived straight, will suffice for the grant of the application. To buttress the point being made, counsel cited and relied on the case of Madubuke versus Madubuke, reported in 2001, 9 Nigerian Criminal Report, part 719, page 689 at 709, paragraphs A to C. According to counsel, in the case at hand, the applicant has disclosed in his supporting affidavit that the first defendant respondent is threatening to suspend him from the third defendant legislative counsel for reasons that the applicant refused to heed to his demand to decamp with him and other elected officials of the third defendant respondent to the APC. Counsel asked the court, in the light of the abandonment in paragraph 14.1, 3, 4, 20, subparagraph 6 and 7 of the supporting affidavit to grant the application for protection of the claimant to grant the application for protection of the claimant rights. Counsel also argued that the present application has satisfied all the conditions for the grant of interlocutory injunction. In concluding his submission, counsel asked the court to grant the application as prayed. In an oral submission, a reply on point of law, counsel for the claimant raised an objection to the counter affidavit in that it was filed out of time without leave of court. Counsel asked the court to discountenance it as it is not properly before the court. Counsel also raised objection to some paragraphs of the counter affidavit for having offended Section 115 of the Evidence Act. Counsel then asked the court to grant the application of the claimant applicant as prayed. The submissions of the defendant respondent. Mr. Omaka Esquire, counsel for the defendant, respondent in oral submissions, relied on the position contained in the counter affidavit and adopted the written address file along with the counter affidavit. In the written address, counsel formulated a sole issue for determination to wit whether in the circumstance of this case, the claimant applicant is entitled to the relief of interlocutory injunction sought. In arguing the sole issue submitted, the claimant applicant is not counsel submitted that the claimant applicant is not entitled to the relief sought on the face of the motion paper for the condition for the grant of injunction sought have not been fulfilled. Counsel further argued that the grant of an injunction is an equitable remedy. Is an equitable remedy at the discretion of the court to be exercised judicially and judiciously. Counsel submitted that it is tried to know that for an applicant to favorably invoke the discretionary power of the court, he must furnish the court with cogent reasons and validly admissible evidence to show that he truly deserves the equitable relief sought. It is argued that the injunction being sought must be refused because it is a respect of completed act. In support of this submission, counsel relied on the Supreme Court cases of La Ferry Nigeria Limited versus National Merchant Bank PLC. He also relied on Obeah Memorial Hospital versus Attorney General of the Federation and another. He also cited Ajewale versus Adetimo and Oji versus Zaria Industries. All citations have been supplied. It is submitted the application of the claimant is to restrain the defendant respondent from giving effect to the letter dated 6th day of September 2021, Exhibit A, issued to the clerk of the said defendant respondent. This, according to counsel, had already been given effect to by suspending allowances of the claimant applicant. Counsel also argued that the alleged unpaid allowances to which legislative boards and constituency project fund are alien and unknown to the extent Cross River State Local Government Law number 22 of 2007. Counsel contended that the claimant's application, being one that seeks to restrain conflicted act, cannot be granted on this submission. Counsel relied on the case of John Holt Nigeria Limited versus HAWUNC, reported in 1993, SCNLR 389. He also relied on the case of AG Abias, Attorney General of Abia State versus Attorney General of Federation. It is also submitted the allowances complained of do not constitute proper rights of the claimant's respondent, deserving of enforcement. To buttress the point made, counsel relied on Akibu versus Oduta, reported in 1991 to Nigerian Police Report Part 171 at page one. where it was held by the Supreme Court that interlocutory injunction can only be granted to restrain certain wrong to a legal right and not to restrain the lawful enjoyment of a legal right. It was further held that mere inconvenience without a proper property right is the subject of the complaint is not enough for a grant of injunction. It is also submitted that the applicant must show irreparable damage before the court can grant an order of injunction. The applicant herein has not done so. There is no abatement that claimant suffered any irreparable damage. The failure to establish irreparable damage is fatal. Counsel on this relied on Obeah Memorial Hospital versus Attorney General of the Federation, Sufra. It is also submitted that damages can subsequently can adequately compensate the claimant in support of this position. Counsel refers to paragraph 10 of the originating summons, where claim for damages was made. It is also submitted that the onus of proving balance of convenience it is also submitted that the onus of proving balance of convenience is on the claimant applicant, and having failed to establish balance of convenience is not on his the balance of convenience, the application cannot be granted. In support of this submission, counsel relied on the case of Geva versus China, reported in 1993, 9 Nigerian Penal Report, part 315, page 97 at 108. The applicant having failed all round, according to counsel for the defendants, the applicant having failed all round to discharge the onus. The applicant having failed to, in all round, to discharge the onus of proof placed on him by law, his application ought to be refused. Counsel also submitted that there is no evidence of financial means for the undertaking to pay damages. In concluding his submission, counsel asked the court to refuse the application of the claimant and dismiss him. Court decision: I have carefully and painstakingly perused all the processes filed in this suit and digested them. I have also listened and considered the oral submissions of counsel for the parties, along with the motion on notice, affidavit in support, the exhibit attached thereto, and the counter affidavit and the written address filed along with it. It is right that an interlocutory order of injunction is not a routine order, spontaneously or slavishly granted following filing of an application to that effect. The order is not automatic. The applicant must satisfy the court of his entitlement to it. Therefore, the court has no duty to grant as a matter of grace or routine. It is a hard matter of law based on the facts of the case before the court. In considering the application, the court should be interested in doing justice according to law and equity. The grant or refusal depend largely on discretion of the court, but like every other discretionary power, it must be exercised judicially and judiciously. That is to say, the discretion must be exercised according to law. Being a discretionary power, the court must look at the whole case and must have regard not only to the strength of the claim, but also to the strength of the defense. I have carefully considered the entire case, carefully considered the entire case put forward by the claimant and the counter affidavit filed by the defendant applicant. It is clear to me what this court is to determine is whether, in view of the facts so far disclosed in this suit, the claimant applicant has made out a case for grant of an order of interlocutory injunction. However, before delving into the merits of the application, I shall deal with certain germane preliminary issues that were raised in the processes filed by the parties and in the oral submissions before the court. The first issue I shall resolve is the invitation by counsel for the claimant for the court to delve into the facts forming the backbone of the substantive suit. The counsel for the claimant applicant has extensively argued in paragraph 4.04 of the written address in support of the application for interlocutory injunction on the validity, lawfulness, and constitutionality of order contained in Exhibit A. It is right to know that courts are enjoined not to delve or decide the substantive suit or issue in a suit at interlocutory stage of the case, as doing so may prejudice the outcome of the suit at the end of or conclusion of the case. In deciding application of this nature, the court should, as a matter of fact, try not to delve into the predetermined issues to be tried in the substantive case. See the case of OG versus Zaria Industries Limited. See also Obeya Memorial Hospital versus Attorney General of the Federation. The court in this type of situation must only confine itself to those issues necessary for disposal of the application without more. It is for this reason that I am conscious not to make any pronouncement on the issues that will be prejudicial to the main question for determination at the trial of the substantive suit. See the case of Bonaya and others versus Ada Farm Nigeria Limited, reported in 1993, 5 Nigerian Report Part 292, page 247. It is in view of this old cherished principle of law that I shall refrain from deciding the crucial questions that are to be resolved at the conclusion of this case. Another issue that need resolution or my attention is the oral objection raised by the counsel for the claimant to the counter affidavit filed by the defendant respondent in opposition to the application for interlocutory injunction. Let me say here that the requirements of filing of counter affidavit within 7 days was a requirement of the rules of this court. The law is settled that rules of court are meant to be obeyed. They are made for orderly conduct of cases before the court in order to do justice to parties. Thus, why non-compliance is regarded as irregularity not capable of initiating the step taken. See Order 5, Rule 1 of the rules of this court. In the circumstances of this case, I consider filing of the counter affidavit out of time as an irregularity. Since the rules have provided for payment of penalty for default, I shall hereby order the defendant respondent to pay default fees at the registry of this court Another preliminary to pay default fee as a registry of the court. In the circumstances, the counter affidavit, the non-filing within time is an irregularity, and I so hold. Another preliminary issue that need to be resolved is an objection raised by counsel for the claimant applicant orally to the effect that the averments contained in paragraphs 14 and 15 of the counter affidavit offend the provisions of section 115 of the Evidence Act. It is tried to law that an affidavit shall contain only statement of facts and circumstances to which a party has deposed either of his own personal knowledge or from information which he believes to be true, excluding extraneous matters such as objection, phrase, legal argument, and conclusion. See the case of Dana Infex Limited and another versus Outcome and another reported in 2005, 3 Nigerian Nuclear Report, Part 968, 544. See also in Jomina versus Uboma and another reported in 2014, LPELR 2249 CA. I have studied the content of paragraphs 14 and 15 of the counter affidavit. It is clear to me that they run contrary to the clear provisions of section 115 of the Evidence Act. I therefore discountenance them. I must also point out here that some of the averment in the affidavit in support of the motion of notice also surpass the same fate as they offend section 115 of the Evidence Act. The paragraphs of the affidavit in support that goes contrary to the provision of section 115 of the Evidence Act are paragraphs 19 and 26, paragraph 19, 20, 21, 22, 23, 24, 25, and 26 of the affidavit in support. These averments have been made in contravention of the law and are hereby discountenanced.
As a copy of this.
The substantive application before the court, an order of interlocutory injunction is an equitable, as pointed out earlier, an order of interlocutory injunction is an equitable remedy issued or granted by a court at the suit of a party complainant, directed to a party defendant in the action, or to a party made defendant to that purpose, forbidding the lector to do some act or to permit his servants and agent to do some act which is threatening or attempting to commit or restraining him in the continuance thereof. Such act being unjust and inequitable, injurious to the claimant, not such as can be adequately redressed by an action in law. It is a judicial process operating in personam and requiring the person to whom it is directed to do or refrain from doing a particular thing. See the case of Nigerian Telecommunication Limited versus ICIC Directory Publishers Limited, reported in 2009, 16 Nigerian Nuclear Report, part 1167, page 356. Therefore, interlocutory injunction is the injunction given which a court of law grants on notice in the course of pendency of the litigation, and which lasts until the final determination or conclusion of it. It is granted to protect the rest in dispute at the time when the true owner is yet to be ascertained, pending the determination of the dispute between the parties. See the case of Salami versus Yaya, reported in 2009, 17 Nigerian Nuclear Report, part 1171, page 581. It is granted to prevent the continuation of an alleged wrongful act. See the case of Inandi versus Amadi, reported in 2011 for Nigerian Nuclear Report, part 1238, page 553. By an interlocutory injunction, the rest is preserved from being dissipated or printed away until substantive suit is decided. This means an order of interlocutory injunction guards and protects the rest during the pendency of litigation. See the case of in Akibu versus and others versus Odutan and others, reported in 1991 to Nigerian Criminal Report, part 171. The Supreme Court held that an interlocutory injunction is usually granted with the object of keeping matters in status quo until the question at issue between the parties is resolved. The reason being behind an interlocutory injunction to maintain status quo is to preserve the rest of the litigation from being wasted, damaged, or printed away, with the result that if the action succeeds, the successful party will have nothing or will reap an empty judgment. See Oyeyemi and others versus Irewole local government, Ikire and others. 1993, One Nigerian Ukilele Report, part 270, page 462. See also Alon versus Darrell Nigeria Limited, reported in 1997 and 1997, 8 Nigerian Ukilele Report, part 517, page 495. See Omoliko and Awachi and several other cases cited therein. The object of interlocutory injunction is to protect claimant against injury by violation of right for which he could not be adequately compensated in damages recoverable in the action if the uncertainty were resolved in his favor at the trial. See the case of Ikwemchi versus Uku. See also the case of Ogunshola versus Usman. See also Adamu versus Attorney General of Nasarawa State. See also Christleaf PLC versus Majeko Dummi, and the case of Yusuf versus International Institute of Tropical Agriculture. All the citations have been provided in an application for injunction in all of a claimant's alleged right. The court will usually wish to consider whether the case is so clear and free from objection on equitable ground that it ought to interfere to prevent property without waiting for the right to be ascertained. This depends on a variety of circumstances, and the Supreme Court has held that it is impossible to lay down any general rule on the subject by which the court ought in all cases to be regulated. But in no case will the court grant an interlocutory injunction as a matter of course. See DYK Trade Limited versus Omnia Nigeria Limited, Sufra. The tendency is to avoid trying the same question twice and to grant injunction only in clear cases. See Down Pharmaceutical and Chemical Company Limited versus Benex Pharmaceutical and Cosmetics Limited. Generally, the most important factors that courts take into cognizance in the grant of an interlocutory injunction have been stated and restated in several decisions of the Supreme Court and need no repetition here. However, for example, the cases of Obea Memorial Estate, Memorial Hospital, the case of Kotore versus CBN, the case of Omeso versus Inebedum, the case of Ezibilo, Chinwuva, and that Falomo versus Bangi, and many other decisions cited there. The one thing that is well settled in law, however, is that the grant or refusal of an order of interlocutory injunction is in the absolute discretion of the court. An order of An order of interlocutory injunction is in the absolute discretion of the court, which discretion, however, like all other judicial discretion, must be exercised judicially and judiciously, having regard to all the terms. It is always essential to remember that in an application for interlocutory injunction, a trial judge invoke his equitable jurisdiction, which require him to exercise his discretion judicially and judiciously based on facts presented by the parties before him and on no extraneous matters. See Macri versus ICC Limited and several other cases cited therein. The burden of proof is on the applicant of the burden of proof on the application for interlocutory injunction is entirely on the applicant, and he must discharge the burden in the affidavit. See Moro Pula versus Kwara State College of Technology, reported in 1990 for Nigerian Criminal Report Part 145, page 506. This does not, however, means that the applicant has the legal duty to prove the merit of the case at the interlocutory stage. The Supreme Court in Palomo versus Banibe and others supra quoted with approval dictum of Lodidenin in the case of Hubbard versus Bospa, 1972, 3 QB 84 at 96, where it was stated that the remedy of interlocutory injunction is so useful that it should be kept flexible and discretionary and must not be made the subject of strict rules. Said it is in the light of the foregoing general principles of law on interlocutory injunction, which govern the grant or refusal of the order of injunction, interlocutory injunction, that I shall consider and determine the application before me. Again, the background and the said general principle of law and the parts of from the press on the motion on notice, an affidavit in support of the motion on notice for interlocutory injunction, and the response filed in respect for interlocutory injunction and the response filed in respect thereof. It is apparent that the main contest by the parties centers on the issues of withholding, suspending, denying, and or depriving the claimant applicant of his allowances, entitlement as serving counselor of the claimant, and serving counselor of the third defendant, and restraining the defendant respondent from entertaining, embarking, or taking any action toward stopping or suspending claimant membership of the defendant. The two reliefs being sought as captured above raise issues of the act sought to be restrained had been completed. Legal right and balance of convenience. There is also consensus in the affidavit before the court that by the Exhibit A, the fourth defendant was ordered or directed by the first defendant to suspend payment of allowances to the claimant. The affidavit in support of the motion on notice clearly evinces that the order or directives contained in Exhibit A has been completed and carried out by the post defendant. This means that based on this prayer one, on the face of the motion paper being sought has been completed. The act based on which the prayer 1 is being sought has been completed. The law is humble that an injunction will not be granted for a completed act. See the case of UTC Sufra. In the case at hand, allowances having been suspended, there is nothing left to be restrained. And an application of this nature is to maintain status quo. And the status quo, as at the date of filing of this suit, is suspension of allowances. That is the status quo that has to be maintained. The second prayer is for an order restraining the defendant respondent from stopping or suspending claimant's membership of the third defendant. The law is tried. An injunction cannot be issued or granted to restrain exercise of legal right. See Akibu versus Odutan. The court does not have power without special circumstances being shown to stop the exercise of constitutional or statutory function. Where the law is settled that an injunction cannot be issued or granted to stop exercise of statutory duty. It is to be noted that granting of an injunction in this case may also have the effect of affecting the statutory functions of the defendant. As pointed out earlier, the law has been well grounded by a long line of decided case law that an application seeking for an order of interlocutory injunction is calling for exercise of discretionary power of the court, which has to be exercised judicially and judiciously in line with the well-established principles governing such exercise. The court, in deciding whether or not to grant the interlocutory injunction, shall be guided by the nature of the serious issues to be determined, balance of convenience and status quo as proper remedy. See OG versus Zaria Industries. The remedy of injunction, as the name implies, is a temporary remedy to last till final determination of the suit. Being an equitable remedy, it is also discretionary. Hence, the central objective of the court is to protect the party applying for injunction against any injury by violation of his right, for which he could not be adequately compensated in damages recoverable in the action if the uncertainty were resolved in his favor at the trial. See the case of Obeya Memorial Hospital, Sufra. In the case at hand, the main grounds of the claimant borders on suspension of allowances and fear of being removed as counselor of the third defendant. If at the end of the trial, this court found the claimant is entitled to the allowances he was denied, the claimant can adequately be compensated in damages. And if there is any action that interfered with the function of the claimant or suspension or removal, this court can reverse all such actions. In the circumstances, the relief being sought have not satisfied the requirement of damages. Some of the reliefs being sought are on damages and payment of withholding of allowances. These reliefs being sought by the claimant are evidence that in the case the claimant got judgment from this court, the injury he might have suffered can adequately be compensated by damages. On this count, the application for an order of interlocutory injunction is not appropriate in the circumstances of this case. The law requires that there should be enough evidence that the applicant will suffer more inconvenience if the application is refused. This fact must clearly be set out in the affidavit in support. See the case of Africa Continental Bank versus Awoboro. See also Gemba versus China. See also Gambari versus Bukola. See also Modile versus Governor of Lagos State, and host of other cases cited therein. However, in the case at hand, the claimant applicant has not supplied enough material to show that balance of convenience is in his favor. The claimant applicant's application for interlocutory injunction has not fulfilled the conditions for grant of the interlocutory injunction. As pointed out earlier, the act sought to be restrained by FREA 1 has been completed, and the act in FREA 2 can be adequately compensated. In the circumstances, the application for interlocutory injunction fails and same is hereby refused. In the circumstances, I ordered accelerated hearing of the substantive suit. Ruling entered accordingly.
As the court please. I'm sorry, my lord.
Yes.
I want to thank my lord for the exhaustive and erudite ruling. Indeed, this is a special court and a court of justice. We have done the needful. We have made necessary. We have made this to enable us comply with your ruling today in terms of accelerated hearing. Thank you, my lord. But my lord, let me just point out here that it appears the defense counsel's name was not spelled. Except I didn't hear my lord. Okon Okama. That is the defense counsel. Okama.
Okay.
Yes, my lord.
Okay.
Yes.
It's noted. I will correct it.
Very well, my lord. Thank you, my lord.
Yes.
Most obliged.
No, I say accelerated hearing. Accelerated hearing. So you give me date, not long.
Milord, sir.
Yes.
Milord, sir, so we're having some technical hitches this way. But do we follow the ruling of his lordship, sir? We quite appreciate so much, sir. But however, sir, may I enter my appearance on record, sir? I'm appearing with DB Aripo.
Wait, confirm me. I'm coming. Yes, counsel, the appearance.
Yes, sir. Our appearance, my lord, sir.
Yes.
Yeah, with humility, sir. I'm Innocent C. Obert.
Innocent C. Obert.
I am with Dixon B. Aripo. And David.
Yes.
Epo.
And
with David Epo, with David Dixon B. Aripo and David Epo.
I'm not seeing David. Where is David? Where is Aripo?
Lord, David Aripo is there.
I have to see his face before I record it. Counsel should put on his video.
Our video is on, my lord. It's on, my lord. This is DB Aripo.
Yes.
And this is David Epo.
David Ekfo. Sit down, you don't need to stand. Did it?
26 January.
When?
26th of January.
Give us 2 days, so that.
26th.
Milord, we thought that given the order of his lordship, we'll be given time within this December, sir.
You say?
I mean, we thought that given the ruling of his lordship, sir, we could be accommodated within December, sir.
Was in December?
Within this December, my lord, subject to your convenience, sir. While the ruling was going on, the belief served us with the processes. That means that pleadings have been exchanged and we're ready to take the trial proper.
I doubt if we will have date in December. Where is your diary? Check December register. You know, the cases are 4, so we find fixing it is difficult because we need to have a clear day.
There will just be for adoption since it's an originating process, originating summons, not hearing in the sense of calling evidence.
Yes.
They are originating processes, not through your ordinary plaints, sir. It's just a matter of adopting what you have filed, which is before his lordship, not the hearing in the sense of taking evidence. So that won't really be Lord's convenience. It will be a lot to accommodate us within December, sir. Because of the nature of the ruling and what we are bringing before his lordship for determination. It's just one defense for all and one claim against all.
Oh, okay.
Okay.
Which day is that?
My lord, that's Monday.
That's it.
Yes, Monday.
This case is hereby adjourned to 13th of December 2021 for hearing.
As the court pleases.
As the court pleases, my
Yes,
lord.
you are welcome. Call the next case.
Number NICN CA 39/2021 between Honorable Evelyn Julius Amina and 1 Honorable Dr. Basi Agara Tom, 2 Honorable Samson Boa Abeng, 3 Obubra Local Government, 4 Mrs. Agatha Patrick Obase. My lord, the parties are absent.
Appearance.
Mr. Miller, with profound humility, I'm innocent of part. I am with Dixon B. Aripo and David Ekpo for the claimant applicant.
Money. Away.
Yes, appearance for the defendant.
With utmost humility, my lord. My name is Okon Okama.
Okon
I appear for the
Okama.
defendant. Okon is spelled O-K-O-R-N.
Yes, Okama.
Okama, O-K-A-M-A.
Yes, for the defendant.
For the defendant. Respondent, my lord.
Yes. This matter is for ruling. The ruling is ready. I don't know, counsel. You know, counsel.
Yes, my lord.
Going through the processes, the prayers being sought, the argument, the contents of the affidavit, and everything is similar to the
Very
case
well, my
that
lord.
to the ruling I have just delivered.
Very well, my lord.
And likewise, the ruling is the same. Do I need to read it all like how I read the first one?
No, we think not.
You said?
We think not so, sir. No need to read, sir. Since the facts are the same.
They are, you know, it's your case now, you know, it is the same. All the argument canvas was the same.
Yes, sir.
In fact, I tried to compare almost words for words, except the parties, names of the parties.
Very well.
So, Mr. Obat.
My lord.
Yes. I said, taking into consideration
No need
the
to read
fact
the entire
that,
ruling, my lord.
okay. So I will only read the conclusion that the application is refused and the court ordered accelerated hearing.
No. The
other last week, don't get change.
So we adjourn to the same day for hearing.
As a couple.
This case is adjourned to 13th day of December 2021 for hearing.
As a couple.
Call the next case.
Suit number NICN CA 40-2021 between Honorable Obetem David Anthony and 1 Honorable Dr. Basi Agara Tom, 2 Honorable Samson Boa Abeng, 3 Obubra Local Government, 4 Mrs. Agatha Patrick Obase. I love the parties out.
Appearance.
The same appearance for the claimant applicants.
Okay.
Innocent C. offered with Dixon Biarico and David Epo.
David who?
David Epo, DKPO.
Yes. Yes, appearance for the defendant.
Respectfully, my lord. My name is
Yes.
Okon Okona.
Yes.
Hearing for the defendants. Sorry, my lord.
Yes. This matter is for ruling. The ruling is ready. We take the ruling as read. The application is refused for lack of merit, and an accelerated hearing is hereby ordered.
As a couple.
This case is adjourned to 13th of December 2021 for hearing.
As a court.
As a couple.
Call the next case.
Suit number NICN CA 41-2021 between Honorable Ochigbe Peter Oke and 1 Honorable Dr. Basi Agara Tom, 2 Honorable Samson Boa Abeng, 3 Obubra Local Government, 4 Mrs. Agatha Patrick Obase. Lord, the party out.
Appearance.
The same appearance for the claimant applicant.
Okay.
The same appearance for claimant applicant.
Yes.
Yes.
Appearance for the dependent.
Same appearance, my lord. Okono Kama Esquire for the defendant.
Yes. This matter is for ruling. The ruling is ready. The application is refused for lacking in merit. Accelerated hearing is hereby ordered. This case is hereby adjourned to 13th of December 2021 for hearing. Thank you very much, Council, for your cooperation. We have come to the end of the virtual sitting. The administrator will end the sitting. Thank you very much.
Thank you, my lord.
Thank you. Thank you very much. Thank you.